Dear guests, welcome to the Dispute Avoidance and Resolution session. As you know, this year's theme is quality, and we also wanted to make a session how dispute avoidance and resolution links with the quality. And for that purpose, we have an external speaker to ADB, and Mr. Thierry Linares from FTI Consulting. He has been working on more than 15 years on live project management issues. He's a dispute board member, adjudicator, and participated in many arbitration proceedings. So we have him. During this session, we kindly request you to interrupt where you have a question. Please ask questions, whether about dispute avoidance, dispute resolutions, or ADB's policies about that. You can ask any questions you have. So we have about 45-50 minutes presentation, and then we'll move on to questions and answer session. Thank you. The floor is yours.
Thank you all for being here this afternoon. As Sina said, don't hesitate to interrupt if we need to make the presentation longer because the questions come first. Do take them first, no problem. So we're here to discuss, and I will sit down a little bit, else I move too much, I know. I move around. So the session is built around dispute management and quality. And first I'll introduce the link between dispute management and quality outcomes. Then for the next three parts, we'll concentrate on disputes themselves, the sources of disputes, the common sources of disputes, avoidance strategies, and resolution methods to be able to have a deeper understanding of dispute resolution. And then we'll circle back into how this knowledge of dispute management can help with performing projects in quality. So first thing, how come we want to discuss dispute management and quality in the same presentation? Well, because in my experience at least, they are intertwined very closely. As Sina said, I've spent more than 15 years on live projects, so I know how to deliver a project badly, because it's very rare to deliver a project in good conditions. Unfortunately, it's not the most common outcome. And it's been more than 10 years now I deal with arbitration, which is when disputes are already blooming, unfortunately. So it means the project has already gone bad. So I was seeing difficult things. Now I'm seeing projects which have already failed. And that led me to a few examples. Let me take a first example. This is a LNG tank, liquefied natural gas tank in Canada, which you see on the picture. There was a problem of quality of the weldings of the pipes around the reservoir due to a lack of preparation from the contractor who somehow forgot he was in Canada and it was going to be cold, as well as a lot of salt in the air because it's near the sea, even if you don't see the sea on the picture. So lack of preparation led to a default of quality in execution and a lot of repairs on the welds. The consequence was an increased cost of manpower due to a loss of productivity and the necessity to pay premium rates to the welders for them to work in difficult and unplanned conditions, and delays. So quality has direct consequences. But worse than that, it led to a dispute between the parties. So further than the technical consequences, it led to a dispute, a request for compensation, which was rejected on contractual grounds by the employer and led then to a situation of arbitration. That's how quality or lack of quality can lead to disputes. One example. Why is that? Because quality can be a threat to the project objectives. And I'm talking about the project objectives, not the party's objective. The party's objectives are different. The contractor wants money. The employer wants a project delivered. But the project itself has objectives. A timely delivery, a budget, safety and quality standards to be safeguarded, and of course ESG impacts to be controlled. That's the main objectives of the project, of a successful project. And in fact, disputes, what are disputes? Disputes are just a loss of equilibrium between the parties in meeting those objectives. And meeting those objectives is normally regulated through the contract between the parties. When the contract doesn't allow the equilibrium to make good or to come back in line, for example, there is more work to do, I will pay you more. Okay, fine. Then no disputes, but there is an imbalance. It was not planned that it would be snowing in Canada, and now it's snowing. I don't want to pay for that. You don't want to pay for that. I don't want to suffer the delay. You don't want to suffer the delay. Now we will fight. That is what is called a dispute, when the contract, unfortunately, doesn't resolve the differences compared to day zero of implementation.
What is any disagreement between the employer and contractor? Can it be called a dispute?
Well, no, that's the point. A disagreement usually, and if the contract works right, leads to a variation, a modification, an amendment. It's quite normal. You've got in infrastructure, in construction, you've got heavy contracts, tens or hundreds of millions of dollars, long contracts, 2, 3, 5, 10 years, it depends. So everybody knows that the conditions signed upon in the contract at day zero will change. Things will happen. There will be modifications. There will be differences of interpretation. And those are not disputes. Those are just normal life. That's why you administrate your contract. Disputes are when this goes sour because it's over the impact, the consequence is over the allowances that the parties had in mind in the contract, or because the risk sharing which was planned in the contract is not respected anymore.
Yeah. So in ADB standard contracts, as you know, we by default use FIDIC. So in FIDIC, for a dispute to become a contractual dispute, you have to give a contractual notice. Something you disagree doesn't become a contractual dispute anymore. By the way, I forgot to ask at the beginning, who are from contractors in the room? Contractors. Consultants? Ooh, consultants. ADB? Okay, okay. Majority is consultants, and then contractors, and then ADB. Good. So I'm sure most of you have knowledge about these, and also we would like to get interesting questions from you.
Okay, so I like graphs, and I do that all by hand. So why do we talk about a dispute, and why what Sina just said is very interesting. A dispute usually would crystallize when there is a formal notification, a formal claim, a formal referral, it depends on the contract, being sent, and the parties fighting over it. That creates cost, but when? If you see on this little design, the cash out of a project is typically very high at the beginning, the investment or capital expenditure period, because you build an asset, so it costs a lot in the beginning. Then for a long time, you're supposed to have operation and maintenance costs or expenses, and at the very end, possible disposal cost or dismantlement. Now, disputes usually come towards the end of the project. That's what I've put in red vertical. So you've spent your budget as it was planned, and then towards the end days, suddenly somebody unearths everything that went wrong and say, look, you owe me $25 million. In addition, bluff, a big peak, which is disputed, but which, let's say the dispute settles, will be paid. So there is a peak of payment. That's a big problem. Why I'm showing that? Because we are in the ADB. And when you have a lender, or if the money for the project has been lended to you, that will be a problem because it's not planned, or maybe by the time the dispute arises and needs to be paid, the lender is already not really present with you. Yeah. And even worse, it can bleed into the operation and maintenance life of the asset. For example, in Belgium, on a power plant which was built, everything went quite okay. The power plant was supposed to have a capacity of 850 megawatts, but it turns out, due to quality default, it couldn't maintain that. It was losing about 10 megawatts capacity unless some extra costs were spent in consumables and in fact in support to the production. So the employer in the end had no choice to accept either a decreased performance or an increased cost to maintain the performance. That's what you see bleeding through the life of the project, and which is also an impact of the quality risk or quality costs.
Thank you.
Now I'll go to another example. Quality is often at the heart of the dispute, I said again, because it's a root cause. It's a root cause for delays, for example. This is an equipment, I don't even remember what it was doing, installed in a nuclear power plant in France. Now, this equipment came in, was shipped from Korea after fabrication, and on site when it was hydro-tested, a leak was detected, unfortunately. And it had to be sent back to Korea to be recast and resent to France. 2 years of delay, because of what? Because of a default in the quality check. The factory acceptance test in Korea initially should have caught that up. Don't tell you whose fault it is, but it was not done properly, so that's a quality cause and a heavy consequence of 2 years of delay with, in dispute then between the parties, the application of 2 years of liquidated damages for delay. You can imagine, of course, nobody wants to be accountable for either 2 years or the equivalent in money. Yeah. That's why I was saying the disputes, honestly, what I see more than 50% relates to originally, at the root cause, a quality issue. I have another one, Ivory Coast. This is a grain silo. Maybe you don't see it very well. It's grain silo with one of the cell which is open here and empty. This asset was about 50 years old, 50, when I first saw it. And due to old age, it had been damaged. So a contractor was called to open this hole and to cast concrete from the inside, shot concrete, to reinforce the structure. That was the plan. And then, of course, fill back the hole. Now, the contractor had poor control and execution, and in particular, a very poor quality of concrete formulation. So the concrete was not holding, was supposed to have 40 MPa resistance, and it was barely attaining 18. This caused, unfortunately, a further collapse during the works. So one of the cells you see, almost collapsed up to, I think there was 1/3 remaining on top, so it's collapsed. Hopefully nobody was injured, but it's still a catastrophic failure, this collapse. And of course, the employer, who was a private client, private owner of this particular asset, lost all confidence in his contractor and terminated the contract. This is just the consequence. The dispute then was related to the fact that the asset being almost completely destroyed, there was a loss of production, and the client went and made a claim for gross negligence against the contractor, meaning that the contractor had failed to uphold professional standards and that it was his complete fault.
And the contract was terminated.
And the contract was terminated.
So I would like to underline gross negligence here. Also, in ADB also we get these questions. If a contract is terminated, what is the limit that the contractor is liable for? Is it just a performance security, which is usually, say, 10%? So contractor pays 10% only, and about that, what happens? But in the case of gross negligence, this may change. What was the example?
Well, the outcome here is extreme, because I took extreme examples, of course, but you're right. The usual liability cap in any contract is between 10 and 20%, because that's a kind of protection for the contractor. He cannot be liable for everything that happens. I mean, shit happens, unfortunately, and you cannot be accountable for everything, except in what is called gross negligence, so meaning you were not performing as you should have been, and this grossly. So what happened here is the contractor was sentenced in arbitration to an amount of damages which was a little bit under 2 times the price of his contract. That's dire. I mean, you understand what a dispute is. The dispute is really the day where what the parties could have expected, what the parties could have anticipated in terms of risk, in terms of allowances, in terms of provisions, because you know things will go wrong a little bit, but when this is blown out the roof, that's what creates a dispute. When you are into the realm of risks not anticipated or of consequences not anticipated.
And I cannot imagine the difficulties of the procedures in that paying 2 times of the contract price.
Yeah.
Arbitration, additional costs, pain, administrative bureaucracy, the time lost.
Well, it was a private client and a private contractor, so the contractor by chance was a very big company, so it was not killing the company, this little piece of work. And they became a very, very good client of me because I had helped here. I had helped the client put forward his gross negligence claim, and the contractor, when he saw that he lost, said, well, next time, Thierry, we'll call you to help us when we have a problem. That was very, very nice of them.
Yeah.
Now, we've gone over a few examples, but there's a lot of sources of disputes, and I just want to discuss a few, because before quality, very often the projects, the construction and infrastructure projects suffer from delays. That's one of the common source of problems. And I wanted to ask by a show of hands, or you can all shout all together, what type of delays have you seen before?
Access to site not given, who has seen?
Yeah.
Priority. Weather impacts?
Not that much.
Scope underestimated? Inference from client? All of the above. And probably others.
All of the above and probably others. I mean, there's a lot of possible causes for delays, of course, and delays, as you know, are maybe, unfortunately, the worst plague, but the most common plague in construction. And delay bleeds into costs. Well, no, first, sorry, I want to do that first now. I'll come back to the other. Delays bleed into cost, because if you look at the dark blue, you have a plan on your project. I plan to do it in 2 years, I ramp up, I spend money, then I finish. Now, if I am delayed, well, I ramp up, I stay up because there are repairs to do, or there is a standby, or there is whatever, and then I finish late. Of course, overall, I've spent a lot more. So the problem of delays, basically, is that it creates overcosts. And why does it do that? That's why I inverse my thing. If you see in the middle, a delay is what? Delay is an activity being delayed. Let's say I build a house, and I build a very simple house. So foundation, 4 walls, 1 roof. You cannot do more simple. If the foundation is delayed, you can imagine that the walls and the roof will go up later as well. So if you look at the right, the successors will be delayed and the project altogether. That's the consequences. But the causes for the delay can be multiple, as we saw. I didn't have enough workers, or I didn't have the materials, or the client didn't have the permit to give me the site and start working, or there's a galaxy of causes which can cause delay. So it's very important, and in particular in dispute resolution, why I talk to you about that, to differentiate a cause and a consequence. What has caused the delay, the cost, either directly or as a snowball effect, and what is the consequence? What is the snowball effect in that case? Because the cause, analysis of the cause will help you try to pinpoint in the contract who take the risk and who took the risk and who took the liability. And analysis of the consequences will help you try to come up with a figure, a compensation, which can be asked, or if it's not money, it could be time, it could be whatever else, but a kind of compensation for this unbalance in the contract.
And in ADB projects, we also often see that when there is a delay, parties come, employers, sometimes contractors, obvious there is a delay, but who is to blame? Like that domino effect, you had a delay in foundation and everything got delayed. I'm sure you consultants, contractors know critical path should have been done at the beginning of the contract. And in many contracts, we see that it is not there. It's not properly there. There is a work program, but it doesn't properly show what the critical path is. And then parties, after 1.5 years, start arguing who is to blame. So there was a float or there was not a float. So it's very difficult. So it's very important that you have the critical path at the beginning.
And if I turn back to quality again, so I had delay, I had overcosts, and I have quality again, because quality issues come in many shapes and forms, either during the contract when there is a need to remedy some issues or mitigate some issues by the contractor willingly, or when the employer or the engineer, whatever the setup, needs to step in and notify for rectification, saying, look, here, this is a non-conformance, please rectify it. Or if it has not been picked up immediately during inspection or whatever, then it may come up at delivery stage, at the point where you want to handle up to take over the asset, and you're doing your reserves, punches, snags, whatever it's called in your contract and country, and there the issues are listed and may delay the delivery, or even worse, after delivery, during defects notification period, or after a project is delivered and defaults remain open, or defaults suddenly come up and the parties discover it after takeover. All of those may create delays and overcosts in turn and lead to disputes. I will always end up my sentences by saying and lead to disputes, I think, unfortunately. So, small example. In the FIDIC contract, which the ADB uses widely and which you may know already, there's a lot of clauses. Those are extracts from the Red Book. It must have been 99. I think I didn't open the 17 for this one. There's a lot of sub-clauses which I've just given you the titles, but you can see from the titles they point out to a share of responsibility and would help, of course, to understand if the cause lies in that subclause or in the other, to understand why a claim or a dispute could be brought up. For example, okay, I'm a contractor, the engineer or the client's engineer doesn't give me the drawings or instruction timely, therefore I am delayed. Therefore, I'm asking for time and money. Or there are unforeseeable physical conditions. Let's go to that clause. Am I entitled to notify for claim, or is it my responsibility? So you see the titles, and it's not even finished. There's a second page. So it's a lot of titles and subclauses throughout the contract that show the risk allocation between the parties, and through that risk allocation that show when something goes wrong, well, you go there, you go to that clause, you reread it, and you think, oh, okay, so the risk was mine, or the risk was not mine, what do I do? And the same goes for the employer. Some of the subclause would point out at possible claims from the employer. And you see a lot of titles here: testing, defects, remedial work, tests, tests on completion, defect notification period, remedy defect. A lot of that is related to the quality I was pointing to before. It's just to show you the examples, not to learn your red book by heart. So that's common grounds for claims. Now we go into the third part. If you've got a claim through a delay, through a cause of quality and a consequence of overcost, for example, what do you do to be proactive about it? To be, I mixed the two words, to be proactive and avoid getting into disputes. Well, I'll take an example here again. This is a tunnel in Georgia, which, as you can see, doesn't look in good shape because it had collapsed. The collapse, the cause, was a problem with the temporary supports. Normally, as you dig, you put temporary anchors and supports to support the shape of the tunnel. This was insufficiently designed, and also the geotechnical conditions were not known well enough, and this was the cause of the collapse. Consequence, collapse. Enormous delays, of course, because it's not very nice, and the need to redesign, in fact, the tunnel to find something that will work. The dispute that arose, request for compensation, request for liquidated damages on the other side, I mean, you can imagine, and unfortunately, this was a project funded by the ADB, and the contractor was told he would not get new contracts if he was not putting his quality standards up to standards, sorry. But that's not my point. My point is this could have been avoided, maybe. Problem is the parties in that specific case were not really proactive, because what happened, the core of the dispute was they were not in agreement on who should have properly looked at the geotechnical condition and designed the anchors. So the party responsible for the cause, the root cause, was not clearly defined in the contract. And that's a lack of proactivity in the contract and between the parties, which led then, when the event happened, to the parties, of course, not understanding each other and disputing and rejecting the fault, one onto the other. Now, what happens is normally you have, and I'm sure in the last 2 days you've gone into a lot of the discussions about procurement, but proactivity and dispute avoidance starts with procurement. And this very early. You have pre-procurement or tendering, where there's an exchange between, I'm not a procurement guy, so I take that at high level, but there's an exchange between the parties, between a need from the employer, I want wastewater treatment built, and a capacity from the contractor saying, yes, technically I know how to do that, here is a delay, here is a price, so a proposal. At that stage already, there is a discussion ongoing about risks. Who takes the risks? Do I submit a price which is based on quantity? Do I submit a lump sum price and I take the risk of quantities? or even in more details about geotechnical studies, etc. Then you go into the actual procurement, signature of a contract. So you discuss contract terms, which should and will, I hope, encompass those discussions and this risk allocation within the parties. So the contract discussion is not just saying, I want FIDIC red, I want FIDIC yellow, I want to write that 20% advance payment is very good to me. This is one part. But the other part, and the most important for me, is the risk allocation. So you go into procurement, then you transfer from procurement to execution, and here there's something very important in this transition, is that the execution project team knows or be made aware of what the procurement team discussed. Because maybe risk allocation was discussed, but the guys who will execute need to know what was discussed, need to understand the contract. Then they deliver, and they manage the contract through what was written. And fifth phase, of course, there's an exit with lessons learned for the next contract, maybe, or an exit with a dispute, I don't know. But there's always something to be learned so as to make it better in the next run, in the next project.
Yeah. Those who are familiar with ADB's procurement cycle will immediately think that this is very similar to ADB's procurement cycle. So you do a country planning, strategic procurement planning, and then the procurement itself, implementation, and then feedback after implementation. So I would like to encourage all, especially consultants and contractors, to pay real attention to the strategic procurement planning phase. Disputes normally happen on the third and fourth places, but you avoid them mostly in the first place, not when they arise.
Yeah. Yeah. Which is not easy, we know that. We know that you want to win a tender, and you don't, you don't want necessarily to show your weaknesses, etc. And the procurement can be fast-paced. We know there are, of course, issues, but the idea is to say you proactively avoid disputes not when they happen, but before they happen. Why is that? This one is a little bit heavy, but it's exactly this. It's at the very beginning of a project. I have not committed a lot of money, and I still have a lot of influence on risks. At day one, I can still change the design of the anchors of the tunnel at the expense of a few man-hours in design. If I'm 20 months into the contract, well, it's too late. The anchors are in the ground, and now the ground is failing, and it will cost millions to rectify. So the cost commitments go up, and the influence the parties can have on any risks and their consequences decreases over time, which is another way to put what we've just said in the previous slides. It's in pre-procurement and procurement that risk should be avoided by thinking about them, by focusing about them, and by doing strategic planning. Now, how do you do that? Well, you write a contract. For those who don't see well, as me, when I am in the room, this is a bulldog trying to get out. This is my picture of a contract. The contract is your guard dog. It's supposed to help you guard the house. But if you give him a little windows like this, it will not guard fuck all. It will be inefficient because one size doesn't fit all. If you're building a road for $10 million, or if you're building a water treatment plant for 100, or if you're building a power plant for 500 million, you will not use the same contracts because you will not likely identify the same potential risks, the same potential problems. The return of experience of your previous similar projects will not be the same. So we'll try to anticipate in each contract risks which are specific to this contract. In which country am I? What is the climate? What are the geotechnical conditions? This is a recurring problem. What am I building, really? Is it something which is, for which the technology is cutting edge? Am I buying a turbine from Siemens which they have never built before? It's the brand new turbine, nobody has tested it. Or am I just doing, let's say, a road, very simple, like I've done thousands of kilometers of before? Those are questions you ask yourself to identify possible risk and then to size your contract. If possible, it's easier for everybody to base a contract on a familiar form, something you've used. For example, FIDIC. A lot of people know FIDIC, they know the terms used. It allows for an easier negotiation. I like FIDIC, but I'm not selling FIDIC here, it's just an example. There are a lot of others. Then, of course, you choose your jurisdiction, your law. There's a lot of choices in a contract, but choices which have influence on what will happen later on. So you try to think ahead, align possible provisions for notification, claim procedures, etc. When you have done all that, you test the draft, if possible, with the project team. So you do a kind of workshop saying, okay, what if it rains a lot? What do we have in our contract? What happens then? Oh, what if a crane falls because of high winds? Who is responsible? Who is liable? What happens? What are we supposed to do? All of that is just contract writing, what I'm describing. But the idea is to say the contract writing through which you will go for sure, because you need a contract, needs to be filled with a fear of the unknown. You need to be ready for the unknown and to try and anticipate risk as you go. That way, the contract will be, the day it is signed and you execute the project with it, will become your best friend and your best tool, because it will have been adapted to your contract.
And on this test your contract thing, we sometimes advise our employers, executing agencies, to do that. And then they say, okay, I did that, and they come up with a draft contract, which now says contractor is responsible for everything. No risk on the employer. What happens? You end up with a very high price. Risk premium will go off. So employer, sharing the risks has a cost. If the employer tends to, okay, let me not be responsible for anything, let the contractor be responsible for everything, then that will have a price.
It's a choice.
That is not the aim here.
No, but a high price or a low price is not a problem. It's a choice. It's my first point, or it should be a choice. If you are surprised by the high price, it's because you don't know what you've asked to your contractor, basically. One size doesn't fit all. And what I've written, it's a bit small below, but a good contract cannot necessarily avoid all disputes. But I guarantee you a bad one will create disputes at least. Now, if ever the contract has not protected you and you have to go into dispute, what happens? Show of hands, because some people have never actually lived through disputes. So I would like to know, who has gone through a dispute with a negotiation, a management negotiation? That much?
Negotiation.
Oh, a bit.
Okay.
Mediation with an external mediator? Yeah?
Yeah.
Okay. Adjudication, arbitration,
we have.
a little bit more. To a local court, maybe? Huh.
Local courts.
No luck. You're not a happy man. Well, it's not fun to go to any dispute resolution forum, but they exist. And they exist because there are mechanisms to settle an issue when the rest has failed. Well, when I say that, I have one example which always comes to mind, even if it's not a lot of fun, but you sign a contract and you anticipate normally that everything will go well. Yes. but you know that stuff can go wrong. Same in a marriage. You went into a marriage, you know you want it to go well, but stuff can go wrong. So a procedure exists to settle and to divorce, potentially. It exists. It's a dispute resolution procedure. Doesn't mean you want it, doesn't mean you think that you will use it at day one, but it exists, it's a pre-agreement by the parties, and it will allow to settle disputes in the future if need be. Now, in construction, on complex contracts, of course, you would get multi-tiered dispute resolution clause. What does that mean? That means there are several levels. You may try or be called by the contract to try for negotiation first, then go to a mediation. If mediation has failed, you can escalate to adjudication. If the adjudication decision is disputed, you can escalate to arbitration. So that's a multi-tier which allows, in fact, to filter the disputes because, say, I don't have figures, but 80% will be killed in mediation, very simply. The 20% remaining, 80% again of what is remaining is killed in adjudication because the parties accept the decision, and only a very fringe of the dispute would need to go to arbitration. The benefits being that you, I said kill, sorry, you resolve the disputes as you go during the contract so as to avoid a pure standby in the contract for commercial reasons. It's less adversarial. You see that we go from negotiation, mediation to more hard stances. Usually it allows for faster, flexible, and cheaper resolution because it's lighter solutions also at the beginning. And then it allows you to go from non-binding, negotiated, to binding because at some point you need to go there if the previous steps didn't work. It allows also to improve cash flow because a quick resolution means a quick invoicing or a quick release of funds if there were funds held. All of those, and that's a big point in construction, all of those are confidential processes. So there's the employer, the contractor, and sometimes mediator, adjudicator, or arbitrator. The ADB, I was discussing this at lunchtime, the ADB may have funded the project but wouldn't even know, possibly, that you are in mediation or arbitration. Not until later on. That's the point, and it's very important for some companies who don't want their image to be tarnished by people knowing they have a dispute or a problem on projects. So those create what I call the continuum for alternative dispute resolution. Why a continuum? Because it goes from the contract. Normally the contract on your left works and allows the parties to find their equilibrium. There's a bit of more quantities, I get paid for a bit more quantities. That's the end of it. It's not even a dispute. Or I enter into alternative dispute resolution by assisted negotiation or asking for somebody to give me an order or even a binding decision. Why is it alternative dispute resolution? Because if it fails, you go back to normal dispute resolution at the far right. And nobody likes that, litigation in front of a court of law, public. And usually in the construction infrastructure industry, it's the least preferred option because you don't know what will happen if I keep very simple.
Yeah. And in ADB contracts, as you know, arbitration is mandatory if it's internationally advertised contract. For national domestic contractors with the employer from that country, we allow litigation. But if it's an international contractor, then arbitration is mandatory.
Now, for those who don't know what it looks like, but very quickly, I've done little drawings. Mediation is basically a red guy helping the greens and the blue to speak together. What does that mean? It means you have a problem, you have a dispute, you think you have a dispute, but before escalation, look, I, as a mediator, as a third party, will help you to talk, will help you maybe elevate the subject, get back out of your trenches, because sometimes it's very conflictual, and see the big picture again. Try to see the project objective, try to see how, by giving a concession, you can help yourself, in fact, for the next steps of the project. So it's to ensure communication before there is an escalated dispute. And it works. It's surprising. For me, it has always been surprising because I trust in hard science, but talking works.
Yeah. But sometimes we get the question, why can't the blue and green talk between themselves without a third party? Why do they, what value does the red guy add?
Well, the parties talk usually, but then they have a dispute because they disagree on interpretation or they disagree on who bears the risk and consequences. The red guy is here the mediator, to try and elevate, to try to put back into perspective. Sometimes he would ask the people around the table not to be the project personnel, but some of the company officials. Tell them, look, this is not necessarily a lot of money for the company, but you're putting a project on hold here for that amount of money. Is it worth it? Did you think about the consequences this will have in 6 months' time instead of being focused on the little points here? So it's more of an intellectual process helping to have a higher view and re-ensuring communication. Now, other dispute resolution methods exist. Here is, for example, if it's technical, let's say my tunnel in Georgia, we don't agree who should have designed the anchors. Well, I will call a guy from Aegis, I don't know, who is a specialist in geotechnical studies. He will look at the documents, the contracts, the studies which were on the table, and he will tell us, well, as a neutral guy, I don't care who wins, who loses. I think this should have been this. Now, this is not binding, but it can help. It can help the parties realize, oh, an outside guy sees it like that. Okay, so maybe let's find a compromise here. I did it, for example, in more commercial evaluation. How much was an anti-corrosion painting system worth? One party was saying, it's worth 0, you should have done it. And the other was saying, well, it's not the same which we specified initially. So what is what? I gave my technical advice, call it, impartial evaluation, depends on the contract, but as an external expert, here is what I think. Now, go back to your negotiation with that addition in hand, and that helps as well. And you hear me, I'm talking about help, mediation, impartial evaluation. Then you can go not to help me help myself, but please decide for me. Please decide for me is the next step. For example, adjudication and dispute boards. And you see the little drawing is a bit different. You've got two parties exchanging documents and talking between themselves, but talking to a head guy and asking for a decision. So a dispute board, and we will talk more about that a little bit later, is somebody who's neutral, not involved for one party or the other, but in a position to know the project and to be called for informal decisions, advice, but also for referrals and a formal decision. So I act as dispute board member very often, and for example, that would be, there's a big variation, there's a big claim, somebody says, look, the ships for transportation, the price has gone up, has been multiplied by 3 due to the war in Ukraine. I think it's not for me to bear that cost, but for the employer. We are disputed about that. Dear Mr. Dispute Board, please don't help me. Please make a decision for us. So, as a little private judge, the adjudicator or dispute adjudication board would make that decision for the parties and say, well, as I reviewed the law, the contract, everything, you should bear the cost, for example.
Yeah, on that point, I'd like to touch a practical point on this. Make the decision for me. Majority of ADB's clients are government, right? They are government officers. The previous methods were mediation, amicable settlement. So you have to, in a way, shake hands with the contractor. A government officer is always afraid to do that. Even if he or she is doing that in good faith, that person can always be blamed because of corruption. And then our government employers
Suspicion of corruption.
Suspicion of corruption, yeah, can be blamed. Suspicion of corruption. So decide for me is a way out. You hire a neutral person, and the neutral, impartial person comes and does the evaluation for you. This also relieves the parties from that kind of responsibility in practice. So we've seen that.
It doesn't necessarily mean that the decision is perfect. It's a decision. Of course, somehow, it has to be imperfect because it has to take a stance. But it's a decision that is auditable, it's given by somebody exterior, correct. It can be acted upon, or it can be refused by one of the parties saying, this is a bad decision, I will not comply with it. Because a decision of a dispute board, depending on your contract, can be either non-binding by law or binding. So it's for you to
and also it can be overridden by arbitration. Theoretically.
So next step, and the ultimate step, would be to go to arbitration. Arbitration being a bit of the same, but very different, because A, it's legally binding. There's an international convention of New York signed in '58 by 130 countries, something like that, for the recognition of arbitral awards. What does that mean? It means if you have an arbitral award in hand, it's as good as a decision of the local court of justice. So I can get an award in Paris, take my flight to Angola where my client sits, put it in front of the Angolan judge and say, look, I want execution of this award. That's protected by the Convention of New York. So arbitration is as good as a decision of law. And basically it's what? It's 1 or 3 or 5, whatever, judges, arbitrators. Why we call them arbitrators? Because they are private judges. That's the big difference.
Yeah.
And how that works, you see the parties don't talk between themselves. We're past that. The arbitrators take the papers, do their magic, decide, give an award, and say, okay, you owe that guy that much, with, of course, an explanation of the why and where, and that decision is applicable immediately, enforceable almost worldwide, and non-appealable.
Okay.
It's final, binding and final.
Yeah. One question, so in the one step before we had dispute boards, but if you end up in arbitration, do the arbitrators take into account dispute board decisions, or do they start looking at things from scratch?
So the powers of the arbitrators are to decide the dispute in its entirety. So they have to look at everything, but they have the power not to be bound by anything. So they will look at what the adjudicator has said before. They will look at the minutes of meeting of the mediation before to understand the context, to understand the good faith, to understand the discussions. Then they will look also, of course, at the pure facts and make their decision. So they are not bound by previous things, but in practice, about 80 to 90% of the time, the award from the arbitral tribunal very closely looks like what the adjudicator had decided, because there's no big magic in the minds, in the legal minds. I mean, if it works, and you will get more or less the same decision. Only in few cases was a previous decision completely overturned.
Yeah, and also in one case, which we've come across, parties went to arbitration directly, without going to the dispute board. arbitral tribunal said, sorry, I can't look at this. You have dispute board in your contract, which you signed, which you agreed. First, go back, do that procedures, and come back to me. That's what they said. I will not look into this dispute until you follow all the procedures in your contract.
Exactly. So now, how do we circle back from dispute management to quality? Well, we try from knowing what dispute management is and what dispute resolution is to go back and integrate at procurement stage the best we can into our contract to ensure quality. What does that mean? For me, it means two words: control and risk control and risk management. It means that the contract needs to establish a risk management approach, a risk sharing between the parties, so that the contract becomes a tool for the parties and not a liability. It means also that you want to induce collaboration between the parties. Risk management allows early warnings. If I know I'm responsible for the design and the outcomes of a bad design, then I can tell very early, dear Mr. Client, please stop it. I've under-designed the culverts. We need to change that before it's constructed. Let's do something about it. That allows a decision. That allows not to have committed too many costs before it's too late. So it's to set up tools to act as early as possible, because as early as possible means with the least possible cost for everybody. Identify variances and claims. So early control and risk management allows to be proactive. We go back there. And we go back to contractual tools also, which are usually forced upon the contractor, but forced upon the contractor can still take it positively. That's what I say to my kids. You're forced to go to school, yes, but you can go there positively and take out the maximum you can. Anyways, you will be there. So anyways, you will have a contract, you will have obligation. Well, try to make something positive with it. So monthly reports, plannings, risk and opportunity workshops, trends, warning, try to use them as good records, as early warnings, as showing for your clients and through your clients to ask for decision, to ask alignment for responsibilities, and to avoid absolutely the wait and see approach, because I promise you, when you wait and see, when you put something in a drawer and wait for it to resolve alone, it doesn't resolve. It starts to rot. That's all it does. Woo, this is written a little bit small, but it's a subject we talked about also. It's contractual tools. Out of the experience, project after project after project, you have things which are built into the contracts already. The risk matrix, the make good clause, taking over processes, the fact that there are bonds, guarantees, penalties, possibility to suspend and terminate, all of that are very important because they allow the interface and the risk sharing to work between the parties. You need risk sharing, but you need boundaries also. I take the risk, but if the risk is exceeded, what happens? How will you be incentivized? How will you be punished, if we say in layman terms? And that is important for a contract, to set the rules of the game and to set, of course, when somebody does not respect the rules, what happens. And the same goes with management tools, which are project execution procedures, which are basically putting in practice those rules to try and make everything go better. So a quality plan, a control of key performance indices, again, the early warnings, or the involvement of a dispute avoidance board, as we talked, are all things which, from experience, allow the contractor and the employer to share tools that will serve the project objectives. And in the end, except exceptional circumstances, because there are always exceptional circumstances, but when you commit and when you reach the project objectives, so when you do what was supposed to be done, everybody is a winner. Or, again, because I'm not always positive, if you don't succeed in project objectives, I promise you everybody will be a loser. And the lawyers and consultants for dispute resolution will charge you a lot of money.
And just I wanted to say, in ADB funded projects, for those who may not know, involvement of a dispute board is the default method in our standard bidding documents, a standing one, not an ad hoc one. You don't go to dispute board when a dispute arises, but you involve the dispute board from the beginning of the contract by, for example, quarterly meetings, site visits to the site.
So questions and contacts. We have a mic here.
Microphone in the middle, please.
Or if you want to just be up and talk, the aim is to take some time to talk between ourselves. Even if the room is big, we can have a civil conversation. And then there is still time also to go outside and take coffee after. We can continue. We can even come back after coffee if some people are very motivated. I have to leave at 5, but it's okay. Yeah. We still have some time.
Yeah. Sure. Thank you so much.
And that's my face for your pleasure.
My name is Zahid Iqbal, and I'm from SMEC. And first of all, I must acknowledge and thank you. I've learned a lot today in the contractual management and the dispute resolution space, so really appreciate it. So I'm going to share a little bit of the situation that we face as consulting engineering, and we caught in the middle sometimes, as sometimes we would be working on behalf of the client as engineers, a representative, or sometimes we can also be a designer. So we pick up the contract as a designer, as a separate contract, and then contract can go as a construct-only contract. So construct-only contract may have sometimes dispute, and those dispute can be cascaded down to, as you know, when the contract will be having an issue that goes to their arbitration, and if the fault is design issue, then it can come to back to the designer as an engineer. So those insurances are there to protect the company. But the point I'm trying to make here, at various instances, no one wants to be in that position of that dispute. That, I think, is certain. Neither the consultant, nor the client, asset owner, nor even us as the engineering consulting company. But many instances where we work, and ADB obviously is also working to the developing countries, developing space, and we find that the asset owner, the executing agencies, developing nations, small country, remote island countries, doesn't necessarily be having all the risk appreciation as an asset owner. And then comes the contracting party, and someone designs, or maybe it can come as a design and contract phase to the contract design and build project. And the competition can be very fierce, and the risk appreciation by various contracting party can also be different. So they ended up going to the party who may have been having high risk appreciation, and later on would be leading into a situation of a dispute. So my point is there, that how do we avoid the situation? Is there a way of actually educating the client more, who are the asset owner, ultimate asset owner, and leading towards avoiding that situation entirely? Someone got to appreciate the risk and have to price that. If it is the contractor, so be it, then the price has to be accordingly. But if the client is not having the proper appreciation of the risk, but again try to pass on the risk to the contractor, and they play a low ball, the results are obvious. And we are managing, like right now in I look after a portfolio of Southeast Asia and Pacific. There are like 7 or 8 contracts that we are managing, roads and other infrastructure, water supply, and there are issues everywhere because of the low ball contracting market. So I will stop here, thank you.
That's a complete question. Well, I would say nothing will ever be perfect, first thing. There is no quick fix to all the problems in the contracting industry. But I I would go back to the pre-procurement and procurement stages. There is an appreciation of risk, as you said, by the contractor and by the employer. The employer or the ADB, for example, the lender, are doing their due diligence. They are doing their due diligence in appreciating the risks for the project itself, appreciating the risk with regards to the different tenders they received. One is very risk adverse, the other is very, I don't know, trusting in his own systems and thinks there is no risk. So normally at tender stage, there are clarifications to allow this risk difference or risk perception difference between the contractors to be leveled out and to be appreciated by the owner and the bank. And then there is something else. The bank or the owner, depending on the setup themselves, have their internal appreciation and may have a provision for risk. I mean, everybody knows that a few things will not be perfect. So they may award a contract for $100 million and keep 5 or 10 in their pocket for the adversity. Just saying figures out of my mind here. And that is how it should be. So as a contractor, I mean, as a bank, as an owner, you do your own due diligence. As a contractor, when you send a tender, it's your responsibility as well to clarify and qualify your offer, not just to try and win, and then you end up in difficulties and you lose money. That's not your interest. But also you can ask to your client, well, you've told us that the design was piles of 20 meters. Okay, very nice, because your designer told you that, but is this based on a, I don't know in Asia if it's called that, but is this based on a G0 or a G2 geotechnical study? Well, oh, it's based on a G0, so in fact you're not entirely sure, so I would need to take an allowance. You can have that conversation, and I think it's important to have that conversation to show the employer, to show the bank that you know what you're doing, that you're cautious about it, not just for your money, but for the project to be successful. And that gives you an edge in first pricing it right, and second, showing that you are open about the risks.
Yeah, correct. And I just want to add on top of that to what you said, ADB has this strategic procurement planning. I want to go back to the procurement cycle. So those risk perceptions and understanding or wrong understanding of risk should be addressed at that time. And normally, typically, not always, but typically ADB provides technical assistance to our borrowers, which are sometimes in the forms of grants. And consultants come there, work with the employer. These are the risks that are potentially we have, and then these are the mitigation risks. So again, coming back to disputes, the problems which you mentioned should be mostly the more influence you will have at the beginning. The earlier you start, the more influence you will have. Yeah, thank you. Yes, please.
My name is Hassan Siddiqui. I run an engineering firm. I have a couple of questions regarding the whole dispute thing. One is the role of the engineer. So even if the engineer is an employee of the consulting or the supervisory team, whether he acts as an individual in terms of liability or responsibility, or the consulting firm is also takes the responsibility of his decisions with respect to the contractual issues. The other question is regarding the DRB. So if the DRB has awarded a claim, whether the client is liable to pay for the claim, to make the payment before he can go for arbitration if he doesn't agree with the DRB's decision, or he can go for arbitration and wait for the arbitration before the payment can be made.
Yeah. Can I reply to that? Yeah. So it has sometimes a confusion whether the engineer should be a person, a real person, or a legal entity.
Yes.
Like XYZ Limited Corporation, consulting. Like, for example, gentleman was from SMEC. SMEC International is the engineer, and then SMEC assigns Mr. X, Mrs. Y as the engineer. That is one option. Sometimes they put directly the name of the person. Then who is liable? But remember, that person is also working for a consulting company, mostly, and then that consulting company has a separate contract with the same employer, in which terms of reference it says that consulting company, not that person, will fulfill the function of the engineer. So in my view, okay, of course every case is different, but in my view, in your example, it will not be the person who is liable if engineers does something wrong. It will be the company who will be liable for that. Of course, I am not talking about integrity, corruption, fraudulent issues, which may involve individual, wrongdoings. But on a technical contractual level, it should be the company.
So just a follow-up question on that, whether an engineer can be liable or not, because engineer is, as far the contract is concerned, is supposed to be treated as the lower court judge, right? So his decision is binding and final, and it cannot be questioned until you go to the higher court of the judgment, right?
Yeah,
so because
there is just words to be adjusted here. The decision of the determination, under FIDIC, the determination of the engineer is nor binding nor final. Not binding nor final. It's not binding by law, and it's not final because it can be, any party can issue a notice of dissatisfaction and go to the next tier of dispute resolution.
No. Of course, it's understood that it's not binding, it's not final, but can it be questioned in terms of his integrity or his sort of understanding of things?
Integrity,
of course, it's not final, so only if it's not final if you take it to the higher authority, but you cannot ask his integrity, right?
I think it can be questioned, and anybody can be questioned under integrity. You don't even need a contract for that. Under the law, in every country there are laws about that, and anybody can be questioned on that. But from a pure contractual point of view, engineer is not a party to that contract. Engineer cannot be contractually blamed under the civil works contract. An engineer can be contractually blamed under its own consultancy contract. That is what I'm trying to say. Under the law is a separate issue. Everybody without contract is bound by the law. That's a different issue. But contractually speaking, contractor cannot sue the engineer contractually based on its own contract with the employer.
And the engineer, again, makes a determination. That's his power under the contract. He says whatever he wants. And if it's wrong, somebody will dissatisfy and go to somebody else. That's it. It's not a case of suing the engineer. It's a case of, this guy is just saying crazy things, let's go see somebody else at some point. And then, after 3 times, the employer will fire you as an engineer. That's it. And replace you.
Yeah. And your second question, dispute board makes a decision. Let's say employer will pay $10 million to the contractor. An employer doesn't pay and goes to arbitration. What happens? If the arbitrary tribunal, as I asked in the question, supports the dispute board, employer will have to pay that amount plus interests and other costs because of the delay. The whole idea of dispute boards I don't know if anybody is familiar with UK adjudication, statutory adjudication, not contractual adjudication. The whole idea is that construction contracts are so expensive. You have a $500 million contract and you have a small dispute over there, right? And because of that dispute, that all 500 million can be suspended. So the idea is that let's resolve these disputes quickly within 28 days and then pay now argue later. That's the whole idea. Dispute board gives, okay, this is the decision. Pay now. You want to argue? Please. You can argue, but don't let the construction suffer. Because maybe public is waiting for a metro. Just because of a small dispute between employer, or maybe there are two not very good characters from the contractor and employee. It happens in life. They are in an argument, and then because of them, the whole construction suffers. It should not suffer. So that is, theoretically, it happens in practice, but contractually should not happen. But if the employer loses in arbitration, he will pay probably much, much more than what he was supposed to pay.
So as long as the DRB awards the claim, IPC can be generated, and the employer is liable to pay that amount before it goes for arbitration.
Contractually, yes.
Okay. Contractually, you have to be a little bit cautious and read your particular condition, because it depends on the countries. But for example, as Sina said, in the UK and under the UK Adjudication Act, yes, of course, it's pay first, argue later. It's to unlock the situation, so to say. It's clear. You put in your IPC payment under referral number 2 following the decision. So you know exactly what you can dispute. And you can say, I pay it now because I'm forced to under the contract, and that way the contractor has no cash flow issue, but I'm dissatisfied and I will bring it to whatever I will bring it to, arbitration.
Yeah. And just for clarification purposes, this payments under dispute boards are eligible under ADB funding. So ADB doesn't say, sorry guys, you shouldn't have done these mistakes. I should not be paying for this additional $5 million, $10 million. Dispute board decisions are eligible for funding under ADB.
Because they are an accessory to the work, in fact.
Exactly, they're part of the contract. Yes, further questions, please?
I like it when everybody's sleeping, because it's after lunch and it's difficult on the third, fourth day for some of you.
Yeah. Okay, if no further questions, I would like to thank you for all, first for coming here. I would like to thank Thierry for flying all the way from Paris to Manila for this event, and then also wish him have a nice flight back in
Thank you.
a couple of hours' time.
No, yeah. Thank you all for coming. It's a pleasure. As you see on my CV, I mean a selected CV, I work everywhere, a lot in Asia as well. So it's a pleasure to come, and I'm sure there will be opportunities for work as well, not only speaking engagements anyways.
Yeah, okay. Thank you.